Okay, so before we begin today's webinar, in our Law for Community Workers series, The Law on Drugs, we would like to acknowledge the traditional owners of the lands from which we are broadcasting today. For me, that's the land of the Widjabul-Waible people of the Bundjalung Nation. We pay our respects to the elders of the land, both past, present and emerging, and we extend that respect to any Aboriginal or Torres Strait Islander people joining us today or watching the recording of the webinar. So welcome to this webinar. Your presenters this afternoon are Jane Sanders from the Shopfront Youth Legal Centre and Andrew Marriott from Legal Aid. After the webinar, you will receive an evaluation survey and we appreciate your feedback. You'll also receive an email with information about any resources that we talk about in the webinar today. I'll now hand over to Jane. Thank you, Jane.
Thank you, Bridget. My name's Jane Sanders. As Bridget has already introduced me, I'm from the Shopfront Youth Legal Centre and I'm coming to you today from Gadigal land, and I acknowledge their elders, pay respects to their elders past and present. Could we please have the next slide, Bridget, which I think has an overview of what we're going to try to deal with today. We're having tech issues with the slides as well, perhaps. Why this topic and what we will cover. Can we have all of those dot points? Oh, they're all coming now. All right. We've got a lot to get through, so we're not necessarily going to cover absolutely everything, but we just want to start off by talking about what is a drug, because different people mean different things when they talk about drugs. The legal status of different drugs, how the law deals with people differently depending on whether you're under or over 18, and also a few recent changes to the law. That will be mostly about drug possession for over 18s, and also a little bit about vaping. Before I go too much further, though, I think maybe Andrew should take the opportunity to introduce himself as well. We're going to share this presentation.
Thank you, Jane. So my name's Andrew. I believe I'm coming from Darug country. So again, one of those, past and present. As for me, I work in the Children's Court. I've been in and around children's law for about 8 years now, and I'm there day to day, every day in the Parramatta Children's Court. You may have spoken to me if anyone's acted as a support person during Youth Hotline, but yeah, in today's presentation, I'll also hopefully address some of the issues from a children's court perspective. But yeah, happy to meet all of you. I'll pass it back to Jane.
All right. Next slide, please. Okay. So when we talk about drugs, a lot of people mean drugs that are illegal, such as heroin, cannabis, methamphetamines, cocaine, and so on. But really a drug, as most people here would know, is any psychoactive substance, really any substance which works on your brain or also has a physical effect. So, of course, that can include things that are perfectly legal, like caffeine, can include things like tobacco, which are legal in some circumstances but restricted. Obviously, it also includes alcohol, and it also includes prescription drugs. So there's lots of different laws around different types of drugs. The one that applies to illicit or illegal drugs is the Drug Misuse and Trafficking Act 1985, New South Wales. Basically, that has a very long schedule at the end of it, which sets out all of the drugs which are regarded as prohibited drugs. The Act also sets out different quantities for those drugs, and the kind of offence you'll be charged with, what court you go to, and how your case is dealt with will depend on the type of drug and the quantity. And I'm not going to go into detail about that now, just so you know it exists. At the end of the presentation, there is a slide, and you'll get copies of the slides later with links to some resources, including a fact sheet on the Shopfront website, which sets out all this. Okay, next slide. So, Andrew, I might throw to you briefly. What are some of the different offences involving illegal drugs?
Yep. Quite a few offences. I suppose the most that we see is possess prohibited drug. Um, can the police prove that you have a drug on you and you have exclusive access to that drug? So you've got possess prohibited drug. Moving up the scale, I suppose, of seriousness, then you've got supply prohibited drug. And again, it relates back to what Jane said about the schedule has the precise amounts about what constitutes possession, what may constitute supply. And then I suppose the greater the amount, it goes up to trafficable amount of drugs. It could go into commercial amount of drugs and then large commercial amount of drugs in terms of supply. So I suppose that's the latter. And there's also a thing called deemed supply. So basically, if you have a certain amount of drugs on you and you have other evidence that may show indicia or signs of supplying it, so it might be text messages or it might be scales or whatnot, the police can charge you with deemed supply. But a counteract to that is you would say, oh, it's for my personal use. But to answer Jane's question, yeah, so it's like a tiered level.
Yeah. So basically, possession, yeah, and self-administration, which police don't often charge, that means using. So it's actually is illegal to use, to smoke a joint or to inject drugs or take pills or whatever. And possession of equipment. All of those offences are sort of on the same level. They're what we call summary offences, meaning that they're generally always dealt with in the local court or the children's court. They're at the least serious end of the scale. Possession of equipment, many of you might already know this, but it's not actually an offence to possess a syringe. That's actually an exception that I think was brought into the law way back in the 80s when, of course, we had the HIV/AIDS pandemic, and that was seen to be a harm minimisation measure to make sure that needle and syringe exchange programs could operate. Bongs, technically a bong, if you're using it to smoke pot, is illegal, but because bongs theoretically could be used to smoke tobacco or whatever, often police confiscate bongs, but they don't charge people because they may believe that they can't prove that it's been used for illegal drugs. As Andrew said, offences like supply and cultivation and manufacture are regarded more seriously, depending on the quantity. If it's commercial quantity, it means you'll end up in the district or maybe even the Supreme Court. In some serious cases of large commercial quantities, you could even be up for life imprisonment potentially. The concept of deemed supply basically is, as Andrew said, if you have more than a certain quantity, the law will assume that because you've got so much of it, it must be for the purpose of supply. It couldn't possibly be for your personal use. And if you're charged with deemed supply, it means that the burden shifts back onto you to satisfy the court that it's not for the purpose of supply. And with drugs like ecstasy, the deemed supply quantity is set at a ridiculously low level. So if it's a drug like ecstasy, you might have only about 3 pills or something and you're in deemed supply territory. Most courts will happily accept that you had that on you for your personal use. So police often don't bother to charge with supply with drugs like that. Maybe the next slide, because we could talk about this for a while, but we haven't got a lot of time. I have sort of explained the difference between summary offences, which are the possess type offences, and indictable offences, which are the more serious ones. If you're an adult and you go to court for possession, which is the most common drug offence by far, you're likely to get a fine. If it's a first offence, or maybe not quite your first offence, the court might deal with you under Section 10, which means a finding of guilt but no formal conviction recorded, which means that you don't get a criminal record. For offences like supply, again, it depends hugely on the amount and the type of drug and your criminal record, and also where are you in the supply chain. Are you the big kingpin, or are you just the dialer dealer who's out on the street supplying drugs for other people? Things like good behaviour bonds, what we now know for adults as CROs and CCOs, they're quite common types of penalties for supply, but imprisonment is definitely a possibility. And if you're looking at very large quantities, then you'll be going to jail. What about for young people, for kids, Andrew?
Yes, I believe it's the next slide, possibly, or thereafter, but basically it's a different regime with young people. Exactly.
Yeah.
There's court alternatives. So under the Young Offenders Act, the police have the discretion, if it's, say, a small amount, to offer a caution or a youth justice conference, but youth justice conference don't particularly, are not common in drug offences. And that's where sometimes, if you've ever been on the youth hotline, if the police are going to give a caution, effectively a warning, then the young person, after getting legal advice from legal aid or ALS, has to admit the offence. So they have to admit the offence, give an interview to that offence, or do what's called a protected admission scheme. So basically admit that they've either in written form or via interview that they had that possession. And then they get given a caution. They don't have to go to court and the matter is dealt with. Police have discretion to issue up to 3 cautions. But if the young person has more than 3 cautions, then sometimes the police hands are tied and they have to send the young person to court. So I've had matters at Parramatta Children's Court. I had one a couple of weeks ago where a young person had 0.01 grams of cannabis. So nothing, absolute skerrick. But the young person had run out of caution, so came to court, and the court can effectively give an unlimited amount of caution. So that young person got a caution anyway. Yeah, so that's the differences. Unless there's anything further to add, Jane, in with the young people and before the Children's Court.
Great, thanks, Andrew. Next slide. So now for adults as well, there are also some alternatives to court for minor possession and self-administration offences. Now, for quite a few years, the New South Wales Police have had a cannabis cautioning scheme. It's an informal thing, like you won't find it in the Drug Misuse and Trafficking Act. You won't find it written down in any act or regulation. It's just a discretionary thing that the police can do instead of charging you and sending you to court. So it's for over 18s in possession of no more than the small quantity of cannabis, which is actually it's a fair bit in the case of cannabis, I think, or who are caught using, right? They maybe catch you smoking a joint and they want to proceed for self-administration. So there has been a cannabis cautioning scheme for quite a few years now, but there were lots of exclusions, like if you had any prior drug offences, if you had any prior violent offences, there were all sorts of exclusions. As a result, a lot of young adults, the kinds of young people that we would work with, were often excluded. A lot of Aboriginal people were excluded, just because people in that demographic are more likely to have records, sadly. But the cannabis cautioning guidelines have been revamped as of a few months ago. They're now available on the New South Wales Police website, and there is a link to them in the Shopfront fact sheet on drug offences. The guidelines are now broader. The only exclusions are if you've got prior convictions for offences like supply or cultivation or manufacture. I think if you've got prior possession offences, for example, you're not excluded. If you've got priors for violence, you're not excluded either. So that's the cannabis cautioning scheme. Even though it has been expanded and revamped, we're still not seeing a whole lot of clients getting cannabis cautions. I mean, it might be that we're not seeing them because they've got the caution and they don't need a lawyer, but we are still seeing young adults being charged, being given court attendance notices for possessing pretty small amounts of cannabis in situations where they might be eligible for a caution. So that's unfortunate, but maybe the police will eventually get with the program. Next slide. So the next slide applies to any illegal drugs other than cannabis. So, things like heroin, ice, coke, whatever. Now, the police have got the discretion, instead of issuing a court attendance notice, they can give you a penalty notice, meaning an on-the-spot fine for $400. They can do that for possession as long as it's no more than the small quantity and it's for personal use, or for self-administration, or for possession of equipment like an ice pipe, for example. So that means you stay away from court. It means that you don't get a conviction, you don't get a criminal record. and you can just pay the fine, or you can put it on a work and development order or whatever. Of course, if you want to court elect, for example, you think you're not guilty because you didn't know you had this substance on you, or actually it wasn't even a drug, it's talcum powder, or the police stopped and searched you illegally, and so you want to challenge the admission of that evidence in court, all of those are reasons why you might decide you want to court elect on the fine and take it to court and make them prove it. But assuming you just want to stay away from court, you admit that you had this drug on you, fair cop, you might just want to quietly deal with the fine and not get a record. Now, there's another option instead of paying the fine, and it's called the Early Drug Diversion Initiative. So if it's the first or second time that you're getting an on-the-spot fine for drug possession, instead of paying the fine, you can instead choose to have I think it's basically an online or phone or sometimes face-to-face counselling session, about your drug use, whether it's a problem for you, etc. If it is a problem for you, then they can give you some referrals. If it's not a problem for you, then they'll probably just give you a bit of a talk about legal status of drugs, and also just what to do, maybe what are some of the early warning signs that might suggest that you are developing a problem with drugs. Okay, so that's an option. Again, there are links to information about this in our Shopfront fact sheet. Again, this has been going just for a few months, the Early Drug Diversion Initiative. Police have had the power to issue on-the-spot fines for drugs for quite a while, but anecdotally, from what we've heard, they don't seem to be doing much of that. Again, we're still getting people going to court for possession, but again, it might take some time for the police to actually realise that they've got this discretion and for it to filter through, but hopefully it does. Okay, next slide. Okay. Just really quickly, we don't want to dwell on this, but there's also the Poisons and Therapeutic Goods Act, which covers restricted substances. So these are the kinds of things that are prescription drugs, right? There are some substances which are both a restricted substance under the Poisons and Therapeutic Goods Act, but they're also a prohibited drug under the Drug Misuse and Trafficking Act. I think maybe things like methadone, perhaps Xanax, certain types of steroids. Obviously, if you've got methadone or Xannies or whatever and they're lawfully prescribed, then you're not committing an offence under either act. Basically, if you're caught with a prescription drug without, and you don't have a valid prescription for it, it's a similar sort of offence to possession under the Drug Misuse and Trafficking Act, similar kind of penalties. But unfortunately, there's no penalty notice or drug diversion available for adults. I think those would still be eligible for cautions under the Young Offenders Act, though, wouldn't they, Andrew?
Yes, they would. Yes, they would.
Yep. Okay. Next slide. This is another thing we don't really want to dwell on because it's a topic all on its own. But everybody knows, I think, that drink driving is an offence. Most of you would have also heard of driving under the influence. And I think most of you by now would also know perhaps that there are offences about driving with drugs in your system, right? Drive with drug in oral fluid. Just might take a moment to explain the difference between those offences and driving under the influence. Driving under the influence is quite a serious offence. It means that you are actually affected by alcohol or a drug, right? So you're actually really intoxicated and probably it's affecting your driving as well. That's not a very common charge because it's a lot easier for police to lay charges, alternative charges, PCA or drive with drug and oral fluid. But where they might charge you with driving under the influence, for example, is if you are taking a drug completely legally. So, for example, you are on opioid medication, pain medication, you've just had surgery, you've got a chronic pain condition or whatever, and you are being lawfully prescribed opioid medication, or you may be lawfully prescribed methadone or bup or something like that. but you've had such a large, your dose is so high that you are really drowsy and you shouldn't be driving, right? But you're behind the wheel anyway and you're clearly under the influence. That might be a situation where you could be charged with driving under the influence. But if you've got alcohol on board, for example, generally you will be charged with PCA, which means prescribed concentration of alcohol. There's different levels according to your blood alcohol reading. Now, with drug driving, there's an offence basically called drive with illicit drug in your oral fluid, blood or urine. There's only one level of offence. It doesn't matter how much you've got. It doesn't matter the concentration. It doesn't matter whether you are intoxicated or affected at all. It is an offence. You can't go to prison for it, right? The worst that you can get in terms of punishment is a penalty, is a fine. But unfortunately, it comes with, if you go to court for it, comes with an automatic disqualification, license disqualification. If you get dealt with by a penalty notice or on-the-spot fine for that type of offence, again, it comes with an automatic license suspension, which you can appeal against. It's really unjust. You could be dealt with for a first offence. You could be dealt with under Section 10 by a court, meaning no conviction, no penalty, no disqualification. But after your first offence, the court can't deal with these offences under Section 10 anymore unless it's more than 5 years. So it's really unfair. We get huge numbers of young adults or actually young people aged 16 and over who've got just a trace of cannabis in their system, including people on medicinal cannabis. There is no actual legal exception for people on medicinal cannabis. If you're on medicinal opioids or something similar and you're taking it in accordance with the prescription, you're not guilty of this offence. But medicinal cannabis, bad luck. You've got to choose between taking your medication and driving, which is very unfair. There's certainly a lot of people campaigning for law reform on this because it's very unfair. And actually, we should also mention, for those that don't know, for children and young people, the law basically says that if you're old enough to have a licence, which means 16 for cars or 16 and 9 months for motorbikes, you're old enough to be treated as an adult. Now, that doesn't matter whether you've got a licence or not. If you're of licensable age, if you've done with traffic offences, you're mostly having to go to the adult court instead of the children's court, unless it's linked to a criminal offence. So, for example, if it's a stolen car that you're driving, you'll end up in the children's court. Andrew, of course, we'd never advise our clients to make sure that, if you're doing dodgy stuff on the road, make sure you steal the car as well, right?
Yes, no, you
ironically, you'll probably get dealt with more leniently if
yes, and I believe, and please correct me, Jane, if you're under 18 but you're sentenced in the local court, they can't sentence you to jail for traffic only.
No, they can't.
No, so that's so don't steal that car as well. It's fine,
No.
Yeah.
Probably enough for now on drugs and driving. Again, that's another whole topic. There's quite a lot of material on the Legal Aid website about alcohol and drugs and driving. We've also got some traffic fact sheets on the Shopfront website. So this slide's, again, just really briefly, if you are in court, at least, again, we're back to adults. If you're in the adult court for drug-related offending, and I'm not just talking about drug offences like possession, supply or whatever, but say you're doing break and enters to support your habit, or you're getting really off your face and you're assaulting people or whatever, you might be assisted by one of these diversionary programs. Marriott is a fantastic program that's available at a lot of local courts, not every local court, but probably most local courts, at least around Metro Sydney. That's for people appearing in the local court who've got a problem. Generally, they have to have a problem with illicit drugs. So they can have a problem with alcohol as well, but they need to also have an issue with other illicit drugs as well. A couple of courts offer alcohol merit. So if your only drug problem is alcohol, you may be able to get onto the alcohol merit program, but that only operates at certain courts. But if it's alcohol and other drugs, then merit's available. Drug court is something for probably more serious offences and more serious offenders, people who are looking at full-time imprisonment. Drug court's now available in not all over the state, but in more areas. It's available pretty much all over Metro Sydney now.
Yep.
In the Hunter area.
Yep.
And at Dubbo now as well. But again, there are restrictions. So violent offences don't qualify for the drug court. So if you're doing break and enters, again, if you've got a terrible drug habit and you need to support it, if you break into people's houses or whatever, doing break and enters without any violence, drug court. But if you're doing robberies and things and sort of actually threatening or being violent to people, you're not going to get into drug court. So I know that people with terrible drug habits don't generally sit down and make rational choices about their offending, but yeah, there are exclusions for violence there. Okay. Better move on. Police powers and drugs. Again, we could probably talk about this all day. Andrew, do you want to talk a little bit about police powers and maybe what are some of the issues that might come up in the children's court?
Yes. So a big, as on the slide, police powers, the police's power to stop and search. Sometimes we have hearings not because they can prove the drug was an illicit substance. It's not talcum powder. It's actually it's an illicit drug the young person has on them. But we go back and see if in finding that drug, in searching the young person, did the police comply with LEPRA, their legislation and their rules. Most namely, was the stop and search lawful? And on screen is basically what the police, what their powers or what their permissions are to search someone, and the police themselves would rely on reasonable suspicion. So how do the police form a reasonable suspicion? Because sometimes at court we have a big argument about whether they formed or whether there was reasonable suspicion. And the police do that by asking questions: where are you going? What are you doing? They might say that the young person looked at the ground, the young person was perspiring, the young person was at this particular point at this time of night. I formed a reasonable suspicion that they had to search them. And that links into why young people should not exercise their right to silence. And another way that the police can get around, I suppose, or they would say they get around reasonable suspicion, is just to simply ask your permission. Can I search you? If you say yes, and that is the same rule for adults, then they don't need to form reasonable suspicion because you've given oral consent for them to search you. So that's the police power for relation to search, but obviously there's also, as on screen, police powers for lawful arrest. There's all these different rules, and for seizing items as well. So for each of those individual powers, there's a set of rules that the police need to follow. And sometimes, as I said before, we would plead not guilty simply because the evidence obtained by the police, they did not exercise their powers correctly, and that evidence should not be used against you at court. Yes. And Jane, do you have anything else to add about that?
No, other than we love running those sort of cases.
You do.
But people, I mean, particularly young people, but really people of any age, as Andrew said, the police often try to form a reasonable suspicion by asking questions or asking for your ID and looking you up on the system and finding some dodgy intel from 2 years ago that suggests you might have been involved with offending of some sort, right? Now, don't make it easy for them. So if they're asking for your name and address, if they're asking you for ID, in most situations, you do not have to provide it. Sometimes you do, or sometimes it's a sensible idea to do it. Like if they've caught you for shoplifting, for example, or travelling on the train without a ticket and they are going to issue you a court attendance notice or a on-the-spot fine, they need to verify who you are, so they're issuing it to the right person. If you want to just get a court attendance notice or an on-the-spot fine rather than being dragged down to the police station to verify your identity, those are situations where it's a good idea to tell them who you are, right? But if they're just approaching you, which they often are, just asking you what you're doing, who are you, where you're going, you don't have to answer that. And I know it's very hard if you're a young person to assert yourself politely, but yeah, you certainly don't have to tell them all the stuff that they're asking for. Don't make it easy. Also, sniffer dogs. Of course, police will use dogs at railway stations and other places like that. If a dog indicates you, that a dog indication alone may not be enough to give them reasonable suspicion because the dogs have a lot of false positives. So police generally look for other things other than just a dog indication. So they'll ask you questions. Again, if a dog indicates you, you don't have to answer any questions. You don't have to give them your ID. You don't actually have to stay there and unless the police have lawfully stopped you. The police are not allowed to stop or detain people while dogs are doing the rounds either. So just bear in mind some of those things. And obviously, if you have clients who are in that situation, who are doubtful about what the police might have done, refer them for legal advice.
Yep.
Okay. Do you want to say a bit about drinking, Andrew?
For under 18s, I suppose the main intersection I get is if police, and please correct me, Jane, but if the police catch young people drinking, what they usually do in my situation is they issue a move on direction. So they ask you to leave wherever you are for a period. I think it's up to, was it 6 to 12 hours?
Yeah. You've got to be actually intoxicated.
Yes.
They can't do a move on direction just for drinking.
No.
But it's if you're intoxicated and acting in a disorderly manner in a public place.
Yep.
Or if you're doing other things like harassing people or, intimidating people.
Causing fear.
Like that.
Yep.
Yeah. Also, they can confiscate alcohol from under 18s, can't they, Andrew?
Yes, they can.
Unless you're under the supervision of a responsible adult. So I think if you're at a family picnic, like with your aunties and uncles and mum, dad, whoever, and you've got adult supervision and they're letting you have, a little bit of grog, that's probably okay. Or you're carrying the picnic basket, with the bottle of wine for mum and dad, that's okay. But yeah, generally, if you're under 18 with alcohol in public place, they can confiscate it. I think they can fine you. It's only like a $20 fine or something.
Yeah.
But it's not actually illegal to drink, if you're under 18. But, obviously there's restrictions about where you can drink. Obviously you can't drink on licensed premises if you're under 18. If you're an adult, like if you're a parent or if you're giving alcohol to a child, if you're actually their parent or guardian, or you're doing it with the consent of the parent or guardian, that's okay. But otherwise illegal to sell or supply alcohol to kids. So if you're 18 and you're buying alcohol for your underage mates, you could be guilty of an offence.
Yep. And just on the point about this tangential move-on directions, if you fail to comply with a move-on direction, it's a fine-only offence. So again, I had a young person where they asked him to move on for this very reason, and he refused, and they arrested him. So, and charged him with all these offences, but that arrest was unlawful. So again, move-on directions are the consequence. If there's no other thing going on, is only a fine as well. So.
Okay. So smoking and vaping. So this is a big topic, I think, among youth workers at the moment. We get lots of questions about it because there's a lot of young people who are vaping and the laws about vaping have changed lately. So very, very briefly, it's not illegal for anyone, no matter what your age, to smoke cigarettes or tobacco or to vape. Right? If you're under 18, though, police can confiscate them from you. So whether that's cigarettes or vapes or, a pouch of tobacco or shisha or whatever it is, any kind of, smoking products, I guess, police can confiscate it. So again, it's not an offence to possess it. You won't get a fine, you won't get a criminal record or anything, but police can confiscate it from you. Okay. It's also illegal to sell cigarettes or buy them on behalf of under 18. So similar with alcohol, there are offences around that. So if you're 18 and you're buying cigarettes on behalf of your mates, you could be in trouble. Laws about vaping. Next slide. We're going to see some changes. So I think, at least on my device, the top of the slide might have been cut off, but from the 1st of January this year, there's been a ban in place on disposable single-use vapes and most non-therapeutic vapes. So these new laws are sort of coming in gradually. From the 1st of March this year, there has now been a ban on import of any vapes without a specific import license. Previously, you were allowed to import vapes for therapeutic use if you were, trying to give up smoking and you were using vapes as a smoking cessation tool. You could import them from overseas under the personal importation program. Now you can't do that. It's only like wholesalers or whatever who can import them. Now, from the 1st of July, there was a plan. What we thought was going to happen was that from the 1st of July onwards, you were going to be able to get vapes only on prescription for therapeutic purposes. What's actually happened with the law is that because there were some amendments moved in Parliament by the Greens, I think, and there was a compromise reached, that for the next 3 months, I think you can get therapeutic vapes only on prescription. But from the 1st of October, if you're over 18, you will be able to get vapes over the counter at a pharmacy, right? Now, the pharmacist has to be dispensed actually by a pharmacist. I don't think you can just get it from, the pharmacy assistant at the counter. The pharmacist has to counsel you about vaping and whatever. They can refuse it if they think that it's not clinically appropriate. They can refuse to give them to you, okay? So it's supposed to be for therapeutic purposes to try to stop you from smoking cigarettes. Now, if you're under 18, it will continue to be only on prescription, right? But basically, as of now, the 1st of July, I don't believe it's legal to buy or to sell or import or manufacture in Australia any kind of non-therapeutic vapes, okay? So clearly there's going to be a massive black market in vapes, and kids are still going to get their hands on them, but the Commonwealth government is really trying to crack down on vaping, and that's the way they're doing it. So they're not criminalising people for actually vaping or possessing them. They're just really, really trying to restrict the supply. Okay. So that brings us to just talking about where people could get legal help. Andrew, do you want to talk a bit about that?
Yeah, just for the Children's Legal Service, I suppose a point of contact, an immediate point of contact is the youth hotline, the Legal Aid Youth Hotline. It's manned by lawyers such as myself. It goes until midnight every night of the week, and it's 24 hours over Saturday and Sunday or the weekend. The main purpose is that if police bring a young person to the station and they want to interview the young person before they proceed, they have to call the Legal Aid Youth Hotline, and that young person has to speak to us in private, away from the police officer. And we speak to the young person, and we also speak to the support person, which some of you may have been in that role. But before the young person speaks, is that the police officer tells us what they're thinking of doing this, how they're going to proceed. Are we going to give this young person a caution, or are we going to charge this young person and take them to court, which our advice is inevitably don't give an interview. So yeah, I can possibly maybe on another slide, but there is a number. It's a free call for the Legal Aid Youth Hotline. And as I said, just to touch upon the other things on the slide, is that we provide free court representation. Does not matter what you've been charged with, from graffiti all the way up to murder and everything in between. Legal Aid, the Children's Legal Service, will represent any young person free of charge. And the visiting legal service, so my role, I also provide advice to young people in custody, such as Frank Baxter, Acmina, all the youth justice centres, just to touch base with the young person to contact us in terms of, going for Supreme Court bail, where's my matter up to? And then, like today, community legal education. So I give presentations today, but I also go out to high schools and youth justice centres, and we give presentations on such things as sexting, consent laws, drugs like today. So just a whole range of issues that are pertinent to young people based on what we see coming through the courts. So that's what we do. And as a takeaway today, any questions, you can obviously contact the Children's Legal Service via Google, but a quicker way would be call the Legal Aid Youth Hotline as well.
Do we have the hotline number on a slide, or did we forget that? What's on the next slide? Yeah.
Up there. Oh,
no.
that's okay.
The legal aid hotline number, though, I know it's 1-800 10 18 10.
There you go.
And that number was, it's there. Okay. So we'll stay on this slide. So legal aid for adults is more of a, it depends more on means tests. So, your income and assets and whatever. And also there's some kinds of cases that legal aid doesn't deal with for adults. Also, unfortunately, there's no legal aid hotline for adults. That phone number, that 1300 number, I think gets you through to Law Access, which is basically partnered up with legal aid and, aims to refer you to the right service. Generally, if you're an adult having to go to court for a criminal matter, you, depending on which court you're going to, you may be able to just rock up on the first court date and see a legal aid duty solicitor on the day. Other courts, you will need to book an appointment for a legal advice clinic at your local legal aid office, and you may need to adjourn your court case to give you time to see legal aid. The Aboriginal Legal Service, they also have a custody hotline. It's called the Custody Notification Service. So if you're a young person under 18 and you're Aboriginal or Torres Strait Islander, I think you can basically choose whether you want to speak to the ALS or the legal aid hotline. If you're an adult and you're Aboriginal, you can speak to the Custody Notification Service. So that is an option for over 18s if you are Aboriginal. They appear at most children's courts and some adult courts. Unfortunately, they don't have the resources to cover every single court. But if it is a court that's covered by the ALS, usually you can just turn up and see an ALS lawyer on the day. The Shopfront, where I'm from, is a legal service aimed mostly at young people who are experiencing homelessness or who have a history of homelessness or at risk of homelessness. We work with young people aged 25 and under, so children and also young adults. We're based in the inner city, but we sort of do work with people all over Sydney metro area. We can provide phone advice and maybe occasionally representation for people outside that area. Generally, we're referral based. We love to get referrals from youth services, so give us a call or send us an email. Give us as much detail about the client and the legal issue as you can. Also, we're very much wanting to be available for questions, just general questions you might have as youth service providers. Also, other community legal centres are worth a mention. Most community legal centres focus more on civil matters rather than criminal matters, but some of them do limited amount of criminal matters, so it is worth trying. A CLC that's really worthy of mention is Redfern Legal Centre, because they have a police complaints practice. So if you're concerned about the way the police might have treated you, strip searching you or whatever, then they would be a really good service to contact. And I think the next slides has just got some resources, some links. But hopefully we've got a bit of time for questions now. I think there's been a few questions posted in the Q&A, so I'm not quite sure if Bridget can read them out or...
Yeah, Jane, we did have a question that came in before the webinar, which was about how the law might impact parents of young children using vapes.
It doesn't. The quick answer is it doesn't at all.
Great, thank you. And the question that we've had in the Q&A during the webinar is, can anyone drink in the street, such as outside the pub?
That's a good question, because there are certain areas that are designated as alcohol-free areas. I think they're designated by the local council and there's regulations made and whatever. So if it's an alcohol-free area, then I think the answer is no, you can't. But
I guess there are also some pubs that seem to have licensing that it extends outside, where they have tables, don't they? I'm thinking of, say, Covent Garden in Sydney.
Yeah. So the answer is it's complicated, but it depends. Like, I think mostly you can drink like in a park or something like that, but if it's an alcohol-free area, you can't. So it's a bit complicated. And if you
So,
are busted drinking in an alcohol-free area, then I think it's a fine,
Yeah.
like a fairly modest fine, and maybe you can get your alcohol confiscated.
so we've had a really interesting comment from somebody as well, that there's a huge demographic of society missing from having legal advocacy. People with disabilities who are often targeted by
Yep,
police with medication, drug carrying, and
yep,
use.
yep,
Youth and Indigenous supports
yep.
are available, but not for people with disabilities who are also
100
vulnerable.
percent agree. 100% agree. I mean, for people with intellectual disabilities or cognitive impairments more broadly, there's the Intellectual Disability Rights Service, also known as the Ability Rights Centre. Um, so they can sort of, I guess, give limited advice. They certainly provide support people. They've got the Justice Advocacy Service, which is a really important service which provides support people at police stations and at courts, and can also link people up with legal advice and diversionary programs. But that's for people whose disabilities are cognitive. Obviously, there's a whole range of other kinds of disabilities out there, which are not cognitive disabilities. And I totally agree. I mean, legal aid will always try to identify if a client is vulnerable. You know, if they do have a disability, they will try to identify that and they'll give them more attention accordingly. But I guess that's a job for you as advocates to just try to advocate for your clients and in getting them access to legal services. But yeah, I agree. More specialist services for people with disabilities would be very helpful.
Mm-hmm.
There was another question I could see in the Q&A is about the early drug diversion initiative. Is it just one session and is it free? Initially, I think it is one session and it's free. If it's your second time, so you know you've previously received an on-the-spot fine and you've gone to that program, I think if it's a second time, you get another follow-up session. But if they identify or you identify that you have a problem with drugs, they could then make some referrals. And I suppose depending on where you live and whether you're eligible, you may be eligible for a service like at your local, local health district. They may have a drug and alcohol service where access is free. But if you go onto the website of the Early Drug Diversion Initiative, that should tell you more details.
Thank you, Jane. I think that might have come in because I had technical difficulties. That question might have come in before I was even able to join because I can't see that.
Okay.
I don't think that we have any more questions that have. Oh, there's a comment about people owning property with disability having service declined.
That's a real, again, that is a problem. In some cases, or Andrew might be able to speak to this because you've worked for adult legal aid
I
service.
have, yes, yes.
Under what circumstances is there discretion around the means test?
Yeah, there's always the exceptional circumstances, but in relation to property, I know I used to work in family law, sorry, many moons ago. So, if that question is in relation to owning a house in relation to family law matters, there is an exception if one party wants to remain in the house, and if there's particular circumstances about the legal matter itself, there is exception for that. For crime, we have as I say, a merit and means test. Is your case strong enough? If you lost your case, would you go to jail? That's the merit test. But the means test, it's put through a system, and if your comes out with a result that you're over on means, there is a right of appeal. So you can take it further, so to speak, through the legal aid system. I think it's the LARC, Legal Aid Review
Legal Aid
Committee.
Review Committee.
Thank you, Bridget. Yes, but yes, generally, yeah, it's not as concise, unfortunately. There are exceptions, again, about exceptional circumstances, but the other way, if you are refused, your clients are refused legal aid for having property, then the best course of action is illegal aid, to appeal your refusal of legal aid.
But there still might be some cases where the answer is just no, or your
Yes.
case doesn't fit. It might also be nothing to do with your assets, but your case doesn't fit within legal aid policies or whatever. I guess that's where other services like community legal centres come in. The Shopfront, if you're 25 or under, which I know, is not everybody. There are also sort of some lawyers or schemes which will represent people pro bono, so fee free. But I guess it's a matter of finding your way to the right people, which of course can be very daunting for a person with a disability. But if you've got a support worker or advocate, that can make it easier. But yeah, we're not here to apologise for the inadequacies of the legal aid system. No. Legal aid gets woefully inadequate funding from the government. What legal aid does, I think, and I can say this, I don't work for legal aid, I think what legal aid does is amazing, but they're not funded to do everything they need to do, sadly.
Yeah, that's right. Sadly, it does just come down to what money there is, and so legal aid has had to refine its policies to direct its services to the most vulnerable. But there are those tests to make sure that the case has merit, of course, and it's a matter that we're funded to provide representation and assistance in. But of course, people always slip through the cracks of any big system, sadly. So if there aren't any more questions, then we might finish the webinar. I just saw something else might have popped up. I think that's all the questions that we've had for today's webinar, and I apologise for some ongoing technical issues that we're having, unfortunately, and it meant that I had to open up a little bit late. So apologies, everybody, but the webinar has been recorded, and I will send a link to the recording so that anybody who wasn't able to join or had problems like I had, they'll be able to watch the recording. And so thank you, Andrew, and thank you, Jane, very much for sharing your expertise in this area.
Thank you.
And thanks, everybody, for joining.
Thanks, everyone.
Thank you, everyone.
Bye, everyone.
Bye.